Here is Mr. Hee-gang Shin.
안녕하세요. Thank you for coming. So, for the benefit of the conference, I will speak in English. Oh, it's on the way around. Where's my slide? Yeah, here. Okay. My name is Hee-gang Shin. I'm a partner at BKL LLC, which known to Koreans as the 법무법인 태평양. I'm in charge of our capital market and IPO practice, and I've been equally practicing onshore IPOs, meaning the Korean companies listing on the Korea exchange, as well as an offshore IPO, including the Nasdaq. Today's discussion will cover not only the Korean companies listing to Nasdaq directly, but also I will also discuss about some of the structural changes of a Korean company to an US or other offshore entity to enable the offshore entity to be listed in Nasdaq. The reason is that even though the entity is not domiciled in Korea, such an offshore entity may be subject to Korean legal requirement, in particular the SRS filing requirement and also the FX reporting requirement, depending on the shareholdings of that company. Just let me show some of the recent precedent. Nasdaq listing of a Korean company is very rare. Actually, the most recent one is the 2021 Double Down Interactive. This is a subsidiary of a Korean listed company, W Games, and is also at the same time a holding company, also US company. So this is a Korean holding company, but it has huge US operation. So this is the possibly the only precedent that Korean company get listed in the form of the ADRs. Other precedents for Nasdaq, we have to go back to 2006. At that time was G-Market, which is now a part of EMART Group, which intermediately purchased by eBay from US side. And also we had some precedent of Hanwha Telecom, now SK Broadband, Gravity, and Wider Than. But this is all just before 2006. And the reason being is that the Sarbanes-Oxley, which increased the cost for maintaining US listing, has affected overall downsizing of the foreign issuer to be listed on the Nasdaq side. At the same time, in 2006, the Korean FSS, 금융감독원, Financial Supervisor Service, has just introduced a new rules pursuant to which the Korean company needs to file a securities registration statement, 증권신고서, when making its public offering outside Korea. Most recent trend from the Korean components of the listing is maybe US flip or SPAC. So one of the recent precedent, which I personally worked on, I also worked on the Double Down Interactive and other G-Market and Hanwha Telecom back in even 1999. But Webtoon Entertainment, a US subsidiary of Naver, listed in the US last year, 2024, transaction. And at that time, also that the transaction was proceeded not only from the US filing side, but also from the Korean filing side as well. And other notable precedent is the most famous one, Coupang. But Coupang is a Delaware company, and they have been designed to avoid some of the Korean regulatory requirements. So there was no SRS filing for Coupang concurrently with the Nasdaq listing. And one of the motivation for using the US on offshore entity is the dual structure that my previous presenter has mentioned, which is not permissible under Korean corporate law. And recently, some of the SPAC precedents were introduced, including the most recent one was the Wave Media, and we also have Captivision on OSR Holdings using the US or offshore SPAC structure This is a listing of an offshore entity, but all the operation through the wholly owned subsidiary is being operated in Korea. The key consideration for Nasdaq listing from a legal perspective, I would like to mention 5 things. Number one, from a offshore, the U.S. flip or the offshore flip perspective, tax is a very key component, meaning that when you just convert Korean company into an offshore entity, there is no tax deferral under Korean tax law, meaning that any difference between at the time when you acquire the shares of the original company and the time of the conversion, the value difference will be calculated as capital gain tax, which means that if that calculation number becomes substantial, it may have a very adverse effect in adopting the structure. So if you consider a flip structure or using an onshore and offshore entity for listing purposes, then you need to just first calculate what the capital gain tax impact that such conversion may involve. The second issue, this is mainly from a Korean listing a Korean entity, and the question is whether the Korean company of Korean shares by itself can be listed in Nasdaq or offshore. Actually, there has been one precedent back in 27 or 20 years ago in 20th century. The company called BRUNET listed its underlying shares without using the ADR structure in Nasdaq. This is a pioneer transaction. Unfortunately, BRUNET is no more existing. But from an legal angle, there is some doubts whether this is permissible from a Korean law perspective. Why? There are two reasons. Under Korean law, if in case you want to transfer the shares of a Korean company, there are 2 ways. Number one, you just deliver the physical certificate of shares to the transferee. It just may not be possible. And secondly, you need to make an account transfer through the electronic system through the licensed brokerage company. This means the licensed brokerage company means a company licensed to brokerage in Korea, meaning that 한국증권회사. It means that any account transfer or electronic transfer outside Korea in US or elsewhere by non-licensed Korean security company may not be viewed as a transfer of shares from a Korean law perspective, meaning that this is not any transfer in a Nasdaq or any other stock exchange outside Korea may not be construed as a valid share transfer, and this could potentially pose an issue from a legal perspective. As such, from a legal perspective, we recommend to just utilize the ADR structure for a Korean company. And the third one is the Korean FX rules. Korea is still a country with very rigorous FX restrictions. For Korean companies to issue securities outside Korea, including ADRs, in excess of $50 million US, you need to procure you need to have a report of an FX report to be accepted by Ministry of Economy and Finance, 기재부. And this is sometimes cumbersome process because the government does not wish the transaction to involve any type of foreign exchange impact. So we would recommend that you consult with the MOF in advance when considering to list your ADRs outside Korea. The first issue is, as discussed very briefly with my previous presenter, the SRS, 증권신고서 issue. That means that under Korean law now, then when you just procure a public offering outside Korea, you should also just process the SRS filing process concurrently with the foreign filing. So the councils, Korean councils and US councils align with the underwriter to make the time plan. As said, it's doable, but need to be meticulously and carefully prepared. And also bear in mind the pricing can only be made once the SRS becomes effective. So you need to just refrain from soliciting investors or just confirm the pricing unless your SRS becomes effective also in Korea. And finally, you need to also consult with relevant authority and stockholders for purpose of the IPO. So let's discuss about the ADR offerings, focusing on the listing of the Korean company itself. It's as said, the preference of the investors is always to list the shares directly, because that the investor can exercise the shareholders' right directly with that company. But for the reason that I have said previously, that it's not it's quite cumbersome for adopting the share listing structure for Korean companies. So we would utilize so-called an ADR offering process, whereby the target company, meaning the issuer and the selling shareholder, deposits its shares with the custodian. It's dominantly by Korea Securities Depository, 한국예탁결제원, and they will coordinate with the foreign depository. For US, typically dominantly by Citi and also JP Morgan, and the depository will issue the ADRs underlying the shares, and such ADRs will be just solicited for the investor to purchase. And from a legal perspective, ADRs are designed to have the practically similar effect as investing in the underlying shares, and the agreement called the depository agreement, which is a very standard agreement, is functioning to act that role. So the ADR holders can exercise shareholder rights through that depository and KSD, the voting rights, the underlying shares, receiving the dividends, or exercising preemptive rights. So although the deposit agreement is governed by New York law, the company's obligation to common shares remains subject to Korean law. The overseas flip, this is designed to convert Korean companies into a foreign entity and enable the listing of the foreign entity directly with the foreign stock exchange. The structure, again, the reason why using the overseas flip is to utilize some of the beneficial structure available outside Korea, especially the dual listing, which dual class of stock mechanism, which was the main motive for coupon transaction, meaning that the controlling shareholder, the founder, can exercise the voting rights more than he or she has. But in Korea, as you know, Korean law only permits that one share, one voting rights. Yeah, the way it is being structured is simply that the existing shareholders of Korean company, CEO, or financial investors or employees, subscribe their shares on US or just Cayman or an offshore entity, and the US or foreign entity, offshore entity, in turn issues new shares to Korean existing shareholder, which de facto functioning as a stock swap or just a stock exchange. Bear in mind, in connection with adopting this structural change, there are certain Korean FX law reporting requirement to be triggered, both to onshore and offshore sites. So you have to just procure all the FX reporting in advance of your structural change. In addition, you have to consider in case the Korean shareholder of a Korean company exceeds 50 or more, then there is a potential risk that the change could trigger another KSRS filing requirement from a Korean securities law perspective. So you need to consult with your legal experts whether this is the case. The SPAC, actually, this is a part of the process utilized by the US flip that I have previously mentioned. SPAC is a special purpose acquisition company listed or already listed, and this will ultimately serve as a consequence of listing this is de facto of a flip process. So the structure could be as similar as the US flip structure we have seen, but in the recent transaction, there are some involvements of US merger sub, Kara exchange sub, and also the reverse triangular merger, which ended up in step 2. So US SPAC, the Korean existing Korean shareholder of Korean company becomes the SPAC shareholder, and US SPAC and Korean company becomes the wholly owned subsidiary of the US SPAC. The similar legal issues as in the US flip will also be applicable in case of a SPAC transactions, but also bear in mind in case the SPAC after Korean shareholder becomes the controlling shareholder of the SPAC, in case the SPAC seeks to make another additional public offering or any type of public funding, then such funding could also be subject to SRS filing requirement. This is the presentation for today. I think I'm also here with my colleagues down around. So if you have any questions, feel free to ask me or my colleagues on the floor. Thank you very much.